Choosing the right business structure is one of the most important decisions you'll make as an entrepreneur. Should you operate under a DBA or form a corporation? Understanding the key differences between these options can significantly impact your liability, taxes, and overall business success. A DBA, which stands for Doing Business As, is not a legal entity, but rather a trade name registration. It allows individuals or businesses to operate under a name different from their legal one. For example, if Jane Smith wants to run her marketing business as Smith Marketing Solutions without creating a separate legal entity, she would file for a DBA. DBAs are typically filed at the municipal level, though some states also handle these registrations. The process is relatively straightforward and affordable compared to forming a corporation. You simply fill out an application with the appropriate jurisdiction where you'll conduct business, which prevents others from using the same name in that location. A DBA makes sense in several scenarios. It provides branding flexibility for sole proprietors who don't want to use their personal name. It allows businesses to operate multiple lines under one legal entity. Financial institutions often require a DBA registration to open a business bank account under a trade name, and it can help protect a sole proprietor's personal identity in marketing materials. However, DBAs come with significant limitations. They provide no legal separation between you and your business, meaning you remain personally responsible for all business debts and legal liabilities. A DBA only protects your trade name within the jurisdiction where you register it. It doesn't establish ownership shares or stakeholder rights. And compliance rules vary considerably between states. If you no longer wish to use a DBA, you must cancel the registration with the appropriate authorities. Requirements vary by state, from submitting a written cancellation letter to completing specific forms. Some states automatically cancel DBAs if not renewed within the registration term, which ranges from annual renewal in some states to every 5 years in others. A corporation, by contrast, is a separate legal entity, distinct from its owners. This separation creates what's often called a corporate shield, protecting the personal assets of owners from business debts and litigation. Every corporation must have shareholders, at least one director, at least one officer, and employees. One significant disadvantage of corporations is the potential for double taxation. Since a corporation is a separate entity, owners must file both personal tax returns and business tax returns. This means profits are taxed at the corporate level, and again, when distributed to shareholders, which can be burdensome for small business owners. A corporation can also file for a DBA, creating what's known as a corporation DBA. This allows a corporation to conduct business under a name different from its legal corporate name. For instance, Elite Tech Solutions, Inc. might operate a product line as Smart Gadget Co. This approach enables market segmentation, testing of new business ventures, rebranding, or franchise models without creating entirely new legal entities. When comparing DBAs and corporations, several factors stand out. Filing a DBA is significantly cheaper than establishing and maintaining a corporation. The filing fees for a DBA are lower, and there are fewer ongoing requirements to maintain it. However, the biggest advantage of incorporating is personal liability protection. Since a corporation is its own entity, owners are generally not personally liable for the corporation's debts or legal issues. A DBA offers no such protection because it's merely a trade name, not a separate entity. Other key considerations include legal status, taxation, formality, cost, name protection, and access to funding. While DBAs offer simplicity and low costs, Corporations provide liability protection, stronger name protection, and better access to capital through shares. Both options come with compliance requirements. DBA compliance includes periodic renewals, which vary by state, and updating registrations when ownership or address changes. Some states require public notices or newspaper publications. Corporation compliance is more demanding, requiring annual reports, shareholder and board meetings with documented minutes, business tax filings, and strict record keeping. If liability protection, growth potential, and investor funding are your primary goals, a corporation or LLC is typically the better choice. For simple branding needs or side businesses, a DBA may be sufficient. The right structure depends on your specific business needs, goals, and circumstances. Remember that a DBA is not the same as a business license. Even with a DBA, you may still need industry-specific licenses depending on your location and type of business. The costs for filing a DBA are typically under $100, while corporations often require several $100s plus ongoing expenses. Ultimately, the choice between a DBA and corporation should align with your business goals, risk tolerance, and growth plans. Consulting with a qualified business attorney can provide personalized guidance for your specific situation.